Good afternoon. My name is Kim Stanger. I'm the head of Holland Hart's Healthcare Group. Welcome to our webinar today. Today we're going to be talking about creating and terminating patient relationships. This is just the latest in our series of compliance webinars that we've been doing for the past couple of months. All of those webinars are available on our website for free. We record those. We also have the written materials and the PowerPoint presentations. If any of you have an interest, you can go and access those past webinars or participate in the future webinars that we have coming up. Today, we're going to be talking about patient relationships. Here's a quick overview. First, we'll talk about how you create those relationships, including situations that you may not want to actually create the relationship, but nevertheless, a court might find that the relationship was created, thereby creating problems for you. We're going to talk a little bit about handling patient problems, and then more importantly, we're going to talk about how you end that patient relationship without getting hit up for penalties for patient abandonment. We're recording the webinar today, so we won't have time to take questions, but if you would like to submit questions, you can use that chat feature through the webinar, or you can just email me at kcstanger@hollandhart.com and I'll respond offline. All right, let's talk about the provider-patient relationship. That provider-patient relationship comes with a bunch of duties. Now, those duties attach once that relationship is created, and they continue until that relationship is properly terminated. So once that provider-patient relationship is created, you have a duty of care. You're all familiar with that. That's the standard of care in the community. And if you breach that, then you could be liable, for example, for malpractice or negligence. If you fail to obtain effective informed consent, you could get hit up with a separate tort cause of action for lack of consent. If you fail to provide necessary care that the patient might need, or you abandon the patient, then you can also be hit up for a separate tort liability for damages resulting from patient abandonment. All of those arise from the duty of care. Once that patient relationship is established, you might also have contractual or statutory obligations too. That if you violate that, you could be subject to breach of contract or certain regulatory or administrative penalties. Now, that patient relationship could either be established through express consent, that's what we wish it would always be, but it can also be implied from this particular situation. So let's talk about that. The general rule is that the patient-physician relationship, it's a consensual relationship, right? It requires that the patient seeks care from a practitioner, and that practitioner consents to provide the care. That's what's necessary in order to have an effective practitioner-patient relationship. I can remember back when I was taking the bar exam courses, sitting in a course, and they were talking about lawyers, and it was an ethics course, and they said, remember, you're not a bus. What they meant by that was we are not required to take on all new clients. Well, it's the same way for you as practitioners. You're not required to take on all new patients. You're not a bus. But there are maybe some limits on when you can refuse care. In general, the patient practitioners can legally refuse to treat anyone they want. Now, of course, that's not necessarily what the ethics rule says. The Hippocratic Oath requires that, or at least states that you'll take care of anybody who needs it. But hey, that's aspirational, not a legal requirement. There are some exceptions, however, that limit your ability to refuse providing care to patients. First and foremost is EMTALA. EMTALA, of course, only applies to hospitals that participate in Medicare and Medicaid and physicians who provide care to patients at the hospital consistent with EMTALA. If you're subject to EMTALA, then you don't have the luxury of refusing to provide care. Instead, if the patient shows up, requests care, then you've got to provide that emergency medical screening exam and appropriate stabilizing treatment thereafter, or an appropriate transfer. We talked about that last week. In addition, obviously, you can't refuse to provide care to a patient for illegal discriminatory purposes, for example, because of race, religion, or nationality, which has been interpreted to include language. This is another issue that I think that we discussed briefly a little while ago with you, that a patient shows up, you don't speak their language, you can't necessarily just refuse to provide care to them. Doing so would violate the discrimination provisions. The government has taken the position, and the Supreme Court has upheld that refusing to provide care to a person because of their language is a violation of prohibitions against nationality discrimination. Now, there are certain limits on that. There are certain occasions when you can, but the general rule is you can't discriminate against people, even those who don't speak. Also, disability, you can't just refuse to see them. The general rule is that you've got an obligation to provide meaningful access to your care to those who don't speak your, even if they have a limited English proficiency, or even if they have a disability. But I refer back to Lisa's presentation on that if you want more information about that. Separate apart from that, there may be situations where you've contracted away your right to refuse care. Maybe you've entered into a contract with a managed care payer where you agree to provide care to all patients within their all insured lives, or maybe you contracted with Medicare and therefore you have an obligation to provide care to at least some certain level of Medicare beneficiaries and the like. Those are situations where you contracted away your right or limited your right. Now, usually that doesn't prohibit you from refusing to provide care to a specific individual, but it might. You might want to make sure that you realize what those limitations are. Maybe you accepted grant requirements. That as part of that grant, you obligate yourself to provide care to certain types of people. Maybe if you're a 501c3 or perhaps a county facility, then you may have charity care obligations under applicable statutes or your obligations as a charitable entity. Most importantly, though, is that once you take on that care, you cannot abandon the patient. If you abandon the patient, then you can be subject to additional penalties like we'll talk about in just a little bit. Now, most of the time, there's not much of a question that you've taken on a particular patient. They know it, you provide their care until you terminate it appropriately. But there can be circumstances where a patient-provider relationship may be established where you didn't necessarily intend to create that relationship. For example, there may be situations where you answer a phone call or you exchange emails with a patient or a prospective patient. That patient thinks that there's a patient-provider relationship, even if you don't. And that raises a question for the judge or the jury about whether or not a relationship was created such that you owe duties to that particular patient. It's particularly an issue involving telemedicine. We'll talk more about that in just a minute. It could be in social media. Maybe as part of your marketing campaign, you have some kind of on your website, you've got a FAQ, or you otherwise engage in social media. And in the course of doing that, you may interact with a potential or patient or a prospective patient. Well, you may never have intended to create any kind of a physician-patient relationship, but that person you're interacting with may think that you did, and may try to hold you liable for any errors you gave in the information that you provided. It could arise in situations where the patient calls for an appointment, makes an appointment, even if you don't necessarily see them. Maybe you cancel the appointment or something, but if it could, in some circumstances, just establishing that appointment could create that patient-provider relationship. It can apply maybe in situations where you provide consultations to a colleague. You have a curbside consult, a client shows up, or another healthcare provider, one of your colleagues, calls you to talk to you about a particular patient. Now, you never established, or you never thought you established a patient-physician relationship with that particular patient, but lo and behold, you're surprised when you're sued along with your colleague because of the advice or the alleged advice that you gave in that process. Maybe a situation where you provide care as a courtesy or as a favor, maybe to a neighbor or to somebody else who may just call you just to ask some questions. You may not think that's a physician-patient relationship, but that other person might. It can arise in situations where you provide emergency care or call coverage. Maybe you're participating in the local hospital's call coverage program. In that situation, you show up, you provide care at the facility, but you don't intend to take on that patient as a personal patient in your practice afterwards. Well, is there a question? Does it create an issue about whether or not you have an ongoing obligation to provide care for that particular patient after they leave the emergency room? It can arise in situations with health fairs or other volunteer situations, especially, for example, in recently with COVID vaccinations or COVID testing programs. Maybe you volunteered to provide services through those particular programs. In the course of doing that, you may have provided tests, you may have provided vaccines, maybe you're at a health fair, you provide a free screening exam, something like that. Does that create an ongoing relationship that you've got a continuing obligation to provide care for that patient, including following up on any test results or anything like that that may come up along the way? Maybe it's a situation you're performing independent medical exams for maybe a lawsuit, or maybe for an employer. Maybe you're doing employer physicals or sports physicals. Maybe you sign up to help the local medical society that's providing free sports physicals to high school students. Well, if you provide that sports physical, are you obligated to provide continuing care or to follow up if you identify a potential problem, or if you order a test and there's potential problems? The key here is that anytime you interact with somebody in the medical field, in medical questions, then there is a potential that that could create a physician-patient relationship, even if you didn't intend that. What you really need to consider is, okay, what would a judge or a jury think? Would the judge or jury conclude, based on the evidence that came out and based on that patient's or that contact's perception of the situation, was there a physician-patient relationship established such that you have some kind of ongoing duty of care in order to protect that patient? So what you want to do to make sure that those unintended relationships don't exist is make sure that you're very careful in how you handle those interactions. Be very careful in what you say or do. If you really want to be safe, then simply don't get involved or give any advice unless you want to assume that you've got a physician-patient relationship. Now, I'm not necessarily advocating that, because you guys are good people. You want to help out others around. You want to be involved in volunteer programs. So if you are going to do that, make sure that everybody involved understands the scope of what you are and are not doing. You should explain the existence or non-existence of any kind of a physician or ongoing physician relationship. Make it clear, if you're going to, for example, provide services through that health fair, that you limit the scope of your care, that the patient understands that, hey, yeah, I'm providing services for this, but it's just limited to do this screening exam. If you're going to get test results, then you need to make sure that you follow up with your regular healthcare provider for the results, that I am not committing to undertake you as an ongoing patient or to provide any follow-up care. You might include appropriate disclaimers or limits on your any kind of consents, registrations, or websites that are associated with those types of events, right? When the patient shows up for that health screening exam or health fair or an IME or some other limited circumstance, you want to make sure that that patient signs some kind of consent, and that consent, they always have to have a consent for treatment. Make sure that that consent is clear, that it only applies to the exam or the care that you're rendering in that instance, that it does not create an ongoing relationship or an obligation for you to provide any kind of follow-up care. Instead, they should follow up with their regular healthcare provider. The key there is to document the parties' relationships in your policies, forms, or consents to avoid any kind of misunderstanding. Make sure that you've got something in paper or something documented so it shows that the patient understood the limits on that relationship. Could be in your discharge referral instructions. For example, if you're providing care at the hospital as an emergency room physician, you want to make sure that it's clear that the patient understands that you're only providing care while they're at the hospital in that emergency room, but it does not necessarily create an ongoing relationship with that patient, and you're not assuming any obligations for post-emergency room care unless the patient contacts you and you otherwise agree to continued care. If there's any question about that, follow up and have communication with the patient. If you are going to engage in all of those outside activities, you may want to check with your insurance company to make sure you actually have insurance coverage for engaging in those other outside activities. You may not think that you're really providing care. Your insurance company may not think or may not agree to provide care for those other situations. You may want to make sure you've got appropriate insurance coverage before you inject yourself in those types of situations. Recently, as I mentioned, this has come up quite a bit in COVID testing programs or COVID vaccination programs. Kind of sample language that I've put into the consents or the other documents, registration documents that the patient will sign would be something to the effect of this. This service does not establish a practitioner-patient relationship, nor does whoever the particular provider is undertake to provide additional or follow-up care for the patient or to advise the patient of the results of any exam, tests, or care. The patient is responsible for contacting their regular healthcare provider to obtain appropriate follow-up care or to address any questions or conditions that may arise. Now, who knows whether that would apply or protect you in that particular jurisdiction, but having an appropriate disclaimer is certainly going to help protect you if there's some kind of an allegation that no, a patient-physician relationship was created and therefore you had ongoing obligations, and by failing to fulfill those obligations, then you have liability to the particular patient. As I mentioned, you've got to be careful about telehealth situations. Telehealth is expanding. It's expanded dramatically during COVID. We've seen a situation where most states, if not all states, have relaxed their telemedicine rules to allow providers to render telehealth across state lines, even though they might not be licensed in that other state. That's not the general rule. The general rules are that in order to provide care to a patient that resides in another state or is in another state, you generally have to be licensed in that other state. And each of those other states may have specific rules and regulations governing telehealth. For example, a lot of states have rules or regulations that govern the establishment of a provider-patient relationship in those telehealth circumstances. These usually grew out of the internet pharmacy situation. Back when the internet kind of took off, we had a lot of enterprising people, pharmacies, that they would go ahead and they would hire a physician. That physician would work in their particular pharmacy or whatever. Patients could call the pharmacy. They would refer that person to the physician. The physician may just have the patient complete some kind of online screening, and then that physician would then prescribe drugs from the pharmacy. Well, it was great for the pharmacy, but state licensors didn't like those situations. Sometimes those pharmacists were not, or those physicians that were providing those services were not licensed in that particular state, or they had not, the state licensing board didn't think that they had done an adequate examination. So as part of that, they came up with statutes that are quite common in the states that require that before this provider of telehealth services can render telehealth services, they have to formally establish a physician-patient relationship. And sometimes those statutes have language concerning what must be done in order to establish that appropriate physician-patient relationship whereby that physician can go ahead and provide telehealth services. So for example, in Idaho, where I happen to reside, Idaho has a law that says that as part of the Idaho Telehealth Access Act, that provider, before they can render telehealth services, must establish a provider-patient relationship through two-way audio-visual or audio interaction that's subject to certain limitations. So you can't just engage in telehealth without having that two-way communication first. There's a bunch of other standards that also have to apply. The key here is make sure that if you're going to engage in telehealth, that you understand what the rules are in that other state for providing telehealth, including any requirements that may exist relating to the establishment of a physician-patient relationship. All right, so once you have created that physician-provider-patient relationship, either intentionally or perhaps unintentionally, the duty of care associates with that. And that requires you to engage in the appropriate standard of care. Let's talk briefly about how you manage that relationship and what the requirements are. Well, in addition to the standard of care, or as part of the standard of care, what we're really talking about in addressing patient relationships, I think, is making sure that the patients and the providers understand each other, that the patient understands the care that they're going to get, they understand the likelihood of success, that they understand the factors and the processes and the like, so that everybody's on the same page. I like this formula that expectations minus actual experience equals frustration. Frustration means that you've got difficult patients, you've got potential malpractice claims, you've got potential claims against your licensure and the like. And almost always it seems that those come out of failed expectations or missed expectations. Well, how do you control expectations? You do that through effective communication with the patient. Make sure that the patient understands what's going on. Have that effective communication. Obviously, at the outset, that effective communication is absolutely critical in obtaining informed consent. Note that there's a difference between an informed consent and a consent form. A consent form does never substitute for informed consent. Consent form, well, informed consent is really effective communication. That's making sure that the patient understands the information they need in order to make an educated, informed decision concerning their health care. It is communication. A consent form simply documents that the effective communication actually occurred, but it's not a substitute for that effective communication. It may help provide some information, but just giving somebody a consent form and asking them to sign it doesn't necessarily mean that informed consent has actually occurred. Instead, you need to make sure that the patient really understands what's in there in order for that to be informed consent, and that informed consent is part of, but not wholly, an important part of making sure that the patient's expectations are satisfied. Even with that informed consent, it's important to have that ongoing communication concerning the scope of services to be provided, the anticipated processes and outcomes, so the patient knows what's really going on, policies and practices that your organization may have when it comes to billing, when it comes to the patient rights and responsibilities. Make sure that you update the patient regularly. Make sure that in those communications with the patient that you listen, understand, and you respond professionally. That effective communication back and forth will resolve a lot of your problems with patients. It will also resolve a lot of your malpractice issues, your complaints that may arise. It's making sure that you manage those patient relationships, manage those expectations, so that everybody's on the same page. When it comes to that patient relationship, make sure that you're aware of any laws, regulations, and contracts that may impose limits or requirements concerning that patient relationship. Your payer agreements with third-party payers may have certain requirements. Your provider agreements and policies internally may have certain promises or tell the patient that you're going to do certain things. If that's the case, then you need to make sure that you make good on those policies or those promises that you're making to them. If you fail to do so, then that could constitute negligence or malpractice or perhaps breach of contract. If you are licensed or certified to participate in Medicare or Medicaid, make sure that you comply with the provider agreements and the conditions of participation that are relevant to that. If you're a facility, there's, as you well know, there's a lot of conditions of participation that govern your relationships with patients. Make sure you're aware of state licensure acts and regulations for licensed facilities and for individual providers. Make sure you're aware of the rules and the regulations that may affect your ongoing patient relationship, particularly under the relevant State Medical Practices Act or similar licensing acts. For example, in Idaho, we've got the Idaho Medical Practices Act has several provisions in there that governs a provider's relationship with a patient, including you've got to comply with the standard of care, no surprise there. In addition, the licensing agency can come against you if you engage in conduct that constitutes an abuse or exploitation of a patient arising out of the trust and confidence placed in the physician. They've added a new provision so that they can come after you for adverse licensure action if you engage in a pattern of unprofessional or disruptive behavior that has the effect of interfering with the effective patient care. Just make sure that you're aware of and you comply with these additional standards that may govern your relationship. If you do have a situation where you're dealing with a problem patient and you would like to terminate them, just make sure that you're careful before you terminate that relationship. You generally, once you take on that patient, you're limited in your ability to terminate that relationship unless you do it in an appropriate manner. If you fail to terminate that relationship in an appropriate manner, then you could be liable for any number of torts or penalties, including malpractice, patient abandonment. You could hit up with civil penalties under EMTALA or the conditions of participation, depending upon the type of facility that you're with or at. It could adversely affect your participation in third-party payer programs, because a lot of the third-party payers, if action's taken against a particular provider, they may kick you out of their program or refuse to re-credential you. It could result in adverse licensure actions, because patient abandonment is usually a part of the Medical Practices Act. If you abandon the patient, the local board of medicine, they may take adverse action against you and kick you out of or sanction you under their licensure action, which comes with a lot of collateral problems for you, including potential adverse action by payers and the like. And of course, you can get hit up with just simply dealing with patient complaints and all of the headaches that arise from that. In dealing with problem patients, it's important to document in the medical record. I get calls quite frequently, surprisingly frequently, from medical practices or facilities that say, hey, we've got this patient here, they're just a real jerk. We want to just kick him out of the practice. And, how do we do that? Well, one of the first questions I ask is, well, okay, what does the medical record say? Does the medical record reflect the justification for your action? Because if you kick that patient out, if they're a difficult patient, it may be that they'll turn around and sue you for malpractice or for patient abandonment or something else. Are you going to have the evidence that you need in order to show that your actions were reasonable under the circumstances and that you did not just abandon the patient? So you want to document if you've got problems with that particular patient, whether that patient's not, whether they're acting in an abusive manner, whether they're not complying with their treatment plan, whatever it is, you'll want to document that in the medical record. If it's in the medical record, just remember that it's probably going to be subject to the patient's right of access under HIPAA. So you'll want to make sure you document that in an appropriate manner and in a professional manner. In addition, even if it's not in the patient's records, it may be discoverable. So again, when you're documenting what the patient does, make sure that you document that in an objective manner. Use quotes. If you're quoting what the patient said, quotes are usually more persuasive. Assume that the patient or some third party, including maybe a jury, may look at those documents at some point in the future. So you want to make sure that you document the patient's behavior in an appropriate professional manner. You may want to not put those types of interactions in the medical record to limit their discoverability. Instead, you may want to put them in an incident report or other record that's protected by your state peer review statute. I defer to you on that, which way you want to go, but just don't assume that that stuff is always going to be absolutely protected. So when you document what the patient's misconduct, make sure that no matter what form you keep it in, it is done in an objective, professional manner, that you won't be embarrassed if it comes to court later on. That documentation is critical in case we need to take additional corrective action against that particular patient in the future, or we need to justify the action that we took. Remember the old adage, if it's not in the chart, it didn't happen. And if you abandon the patient, you terminated that patient because of a bunch of stuff that you say they said, but there's no record of it in the medical record, that could be problematic for you. I found it helpful in dealing with problem patients if you address these issues up front. I think that it's helpful for any organization, whether it's a hospital or a physician practice, to come up with a document that discusses the patient's responsibility as well as the patient's rights, right? It's not uncommon to give the patient something that talks about your responsibilities, including, there's privacy practices, or with your facility, you have to give them the notice of patient rights. But you could also give them a document that talks about the patient's responsibilities, including their responsibility to cooperate in the development of the treatment plan, to comply with the treatment plan, to communicate regularly with their provider, including raising any concerns or questions that they might have, to act in a professional, respectful, non-disruptive manner. And then you put that in some document that you give to the patient. You may actually even just, either as part of the registration process, you give it to them, or post it up at your facility or the like. And then if there are problems that arise with that patient, you can always refer back to that document, right? You can tell, well, as we discussed when you joined our practice or when we provided care, you agreed that this was a condition, that you needed to act in a professional manner, or that you needed to cooperate in the development of the treatment plan or participate in the treatment. And if they're not complying with those, then that provides support for the justification for terminating them. If you've got a patient that's acting improperly, then you may want to sit down and have some kind of a patient care conference, and perhaps even require that the patient sign some kind of a patient care contract. These patient care contracts, these patient contracts are quite common when you're dealing with drugs or substance abuse disorders, but they can actually be used in a broader situation. I've had situations where a patient is very disruptive, and the client didn't want to terminate the patient immediately. We wanted to try to work it out. So we would sit down with the patient and say, okay, these are the problems that we're having. If you've got a patient's rights document or patient responsibility document, it's good to refer back to that and say, look, when you joined our practice, you agreed to the following. And in our recent interactions, these are problems that we've had. If we're going to continue to provide care to you, we need you to comply with the following. And then explain to them things like that they need to cooperate in developing the treatment plan, comply with the treatment plan, participate in a professional manner. Warn them that if they refuse, if they fail to comply with those, that we're going to have to that relationship and they're going to have to go elsewhere. Or at the same time, you may advise them that they can go elsewhere right now. But the key there is you've given them kind of this warning, that you've documented what your expectations are, so that if you do need to take future action against that patient, that you've got the justification that you need. Now, these aren't necessarily required, because remember, you're not a bus. You can generally terminate for any reason or no reason at all, as long as it's not a bad reason. But these types of things will help you if the patient turns around and sues you for patient abandonment or malpractice or the like. It shows your reasonableness. All right. Once you got that patient, you've got that duty of care, and that duty of care has to terminate or continues until you terminate that relationship appropriately. Now, what does it mean for an appropriate termination? Well, it kind of depends upon the provider, because different provider types have different rules concerning how they can terminate that relationship. For example, with hospitals, there's new rules concerning with the conditions of participation applicable to hospital and cause, about you have to have the discharge plan, right? You have to give them the notice. The patient has a right to certain appeals. So you've got to jump through those. Long-term care facilities, you generally also have obligations to give the patient advance notice. They have some appeal rights and things like that. When it comes to physicians and providers, you certainly have to comply with the standard of care, and you have to avoid patient abandonment. What is patient abandonment? Well, patient abandonment can be a tort, a cause of action, just like malpractice, that a patient can sue you for. They can file a civil suit and claim damages against you. The common elements for this tort, the patient would have to establish the following: that there was an established doctor-patient relationship. That gets back to that discussion we had before about making sure that it's clear whether the relationship did or did not exist. If you have clarified or confirmed in writing with the patient the limits of that may help you defend against some kind of a claim that you abandoned the patient. So the first thing is they've got to establish a doctor or provider-patient relationship. Second, that the provider abandoned the patient while medical attention was needed. That's really the guts of this whole claim, right? That you undertook duties as a provider, and somehow you failed to provide that care that was necessary, resulting in damage to the particular patient. Generally, they would have to establish that the patient was not given adequate opportunity to transfer their care to another provider. The patient abandonment doesn't require you to continue providing care forever for that particular patient. It only requires you to give them sufficient time to transfer their care to somebody else and provide necessary care in the meantime. Finally, in order to have a patient abandonment claim or to recover damages at court, the patient would have to establish that they suffered some kind of damages as a result of the abandonment. Now, if the patient just decides to file a complaint with the licensing board or with third-party payers or the like, they don't necessarily have to establish damages when they file that complaint. But if they want to sue you in court, that's going to be an element of what they're going to need to establish. So what is patient abandonment then in its broadest sense? Patient abandonment is generally failing to follow up or providing ongoing needed care. It's, most of you would not intentionally abandon the patient, but you just need to understand that patient abandonment can arise in situations where you're not just willfully failing or refusing to see them, but it can be situations where maybe you provided care to the patient, you think everything's fine, but that patient hasn't heard from you for a long time and they're upset because there was no follow-up following surgery. They had questions, they submitted questions and you're not responding to them. Maybe it's a situation where you decided to go off on a well-deserved vacation, but you didn't make any arrangements to provide coverage for your patients while you're gone, and patients suddenly have some kind of adverse reaction while you're gone and they don't have anybody to provide care in the meantime. All of those situations can arise and give rise to patient abandonment claims. If not lawsuits, then at least complaints to the relevant licensing board or disgruntled patients. It can also arise and usually occurs in the situation where you terminate the relationship or close your practice without giving sufficient notice. There's really three elements to avoiding patient abandonment. To avoid patient abandonment, you need to make sure that you give appropriate notice that you're ending the relationship, time for the patient to find a new practitioner, and provide any necessary care until that patient can transfer their care to a new practitioner. If you fail to do that, then that's patient abandonment. You can be responsible for damages in the lawsuit. You have action against your licensure, and you could be subject to, you as an individual could be subject to adverse employment action or adverse payer action because you failed to comply with your duties and obligations. Well, when it comes to terminating the relationship, remember, you are not a bus. You can terminate the relationship for any legitimate reason or no reason at all, so long as it's not a bad reason. Now, this is in general, right? It's kind of like employment at will. When you employ an employee at will, you don't have a contract with them. You're not required to keep them on for any particular point of time. You can terminate them for any reason or no reason at all, right? So long as it's not an illegal reason. So what are some legitimate reasons for terminating a patient relationship? Well, you're unable to provide their needed care. Maybe they need services that you simply don't feel competent to provide. It could be a situation they fail or refuse to pay their bills. Hey, outside of EMTALA, you're not necessarily required to do this stuff for free. And if the patient isn't going to pay, then you can go ahead and terminate their relationship, but you have to do it in the right way. It could be a breakdown in the relationship or communications. You just don't feel comfortable providing care for this particular patient anymore. The patient may have engaged in disruptive conduct. Maybe they're not compliant with their treatment. Maybe they've missed appointments. It could be any reason or no reason at all, right? So long as it's not a bad reason. What are bad reasons? Well, you can't discriminate against them. You can't fire them just because of their race or, in some states, sexual orientation or the like. But what are some of the factors you should consider before you decide to pull the trigger and actually end that patient relationship? Now, you're not required to do these things, like I say, because it's a consensual relationship. You're not necessarily required to provide ongoing care. You could terminate the relationship simply because you're too busy and don't want to keep them. That's okay, as long as you don't abandon them in the process. But before you make that decision, you're going to want to look at the overall situations, the overall circumstances. It's similar to if you're going to terminate an employee. If you come to us and ask about terminating an employee, we're always going to tell you, well, okay, you can do that, but let's look at the risk factors. Are they in a protected class? Are they a whistleblower? Are there things like this that are going on that increases the risk that even though you're entitled to terminate them, if you do terminate them, is it going to create a potential risk for you? Well, same kind of things with patients. So here's some of the factors that you may want to consider before ending that patient relationship. Most importantly is the patient's current healthcare needs. Are they in the middle of a treatment regimen such that if you terminate the relationship, they're not going to get necessary treatment, or they could be adversely affected by that? That's obviously vitally important to determining how you end that relationship. What's the availability of alternative care? If you don't provide the care, is alternative care out there? What's the basis for termination? Is it, because they engage, it's a legitimate reason that you're doing what you did, that they engaged in disruptive or threatening behavior? Or is it simply that, they parked in your spot when you didn't like it to want them to? What would a jury think if you had to explain the reason for terminating that relationship? Is the patient in a protected class, whether because of age, race, disability, nationality, they're a limited English speaker? If so, then you may have the right to go ahead and terminate that relationship. But if you do, then there's a good chance that they may come back and sue you or file a complaint with the Office for Civil Rights for illegal discrimination. Do you have documentation supporting the termination that justifies why you did what you did? Again, it's not absolutely essential that you do that, but if you have to explain why you did what you did and defend yourself, do you have the documentation you need to? Or would it be better to consider alternative actions before you take that final step? For example, is there documentation that you gave warnings, or should you give the patient warnings? Maybe you had an effective patient care conference or a behavior contract. If you've got that in place and you can show that you tried these alternatives shorter than termination, and then you ultimately have to terminate that patient relationship, these things can help you. If ultimately, however, you decide that termination is necessary and appropriate, either because of misconduct or simply you just don't want to see this patient anymore, that's generally okay. You're generally not required to continue to see them unless you've contracted away your right through some kind of contract or the like. You can go ahead and you can terminate that relationship so long as you satisfy the following. Again, it's the keys to avoiding patient relationship. First, you have to notify the patient in writing and perhaps orally. Second, you need to give sufficient time to transfer the patient's care to another provider. Third, you have to provide necessary care in the interim. And four, you should probably take appropriate steps to facilitate that transfer of care. Let's talk about each one. About first, the notifying the patient in writing and perhaps orally. Well, obviously you want to have something in writing to the patient so that you've got proof, right? But, some people will say just send them a certified letter. I'm okay with a certified letter. Actually, I'd rather send it by FedEx or UPS because if you send it by certified letter, then that's held at the post office. The patient may not actually go down there and pick it up, right? What are they going to say? Patient comes back and says, hey, the doctor abandoned me. Doctor says, oh, I sent him a certified letter. The patient says, oh, I was too sick. I couldn't get down to the post office. I never knew that he failed to give me the notice, right? So I like the idea of actually sending it to them by UPS or FedEx that's actually delivered there and you've got some kind of documentation of receipt. I also think in certain circumstances, it may be appropriate to notify the patient first orally, especially if you've got a relatively good relationship so that they understand. Because remember, the key there is to notify the patient. It's not just simply to send a letter. The key is to make sure that the patient gets the word that they need, that they understand that, okay, I've got to go get my care someplace else. If they never get that communication or don't understand that communication, then there's a real problem, right? We need that patient to make sure they understand that they need to get care someplace else. If they don't get the necessary care and there's an adverse outcome, then they're going to come back against us. So we want to make sure that they actually do get that notice, and therefore just dropping a certified letter in the mail may not be sufficient. You need to want to make sure that they actually get the notice that they need. Second, in that notice, you want to make sure that you give the patient sufficient time to transfer the care. Well, what is sufficient time? Well, 30 days is standard. That's kind of what most people recognize. So at least give them 30 days, but it really depends upon the circumstances. Remember, the whole purpose of avoiding patient abandonment is to make sure that that patient is not damaged. So the question is, okay, how much time did this patient need to transfer their care to somebody else so that they won't be damaged? Well, if you're in the middle of you're an oncologist and you're in the middle of a treatment regimen, well, you may have to finish that regimen before that patient can transfer their care without being damaged. If you're an OB and you're treating a patient who's 8 months pregnant, well, you may not be able to transfer that patient in enough time to allow them to get care to somebody else and to assume that care before that person delivers. If, on the other hand, you're a primary care physician, you see this patient once every 6 months or a year for an annual physical, well, there's probably not much damage, right? There's a real question about whether there's even an ongoing relationship, but there's likely not much damage if you give them at least 30 or give them up to 30 days. You could probably give them 2 weeks and there's not much damage that patient's going to suffer because they could go get their care elsewhere. So it really depends upon the circumstances. The general rule, 30 days, but look at your circumstances. Next, you've got to make sure that whatever time period you put in there, the 30 days, you've got to provide care in the meantime so that until that time's up so they can reasonably transfer their care to somebody else. Because if you fail to provide the care in the meantime, well, that's abandonment. That's where the patient gets damaged. That's where you can be liable. That is the definition of abandonment, right? So you need to go ahead and make sure that you provide any necessary care in that interim. And you should facilitate the transfer of care. In that letter, normally you would say something like, if once you transfer your care, have them contact us, we will transfer appropriate records. You may want to give them some referral sources. You might say that if they need help finding another provider, they might check with their payer, with their health insurer, or check at the local hospital, or check at the local, other resources where they might be able to find somebody else to transfer the care. And then you're going to want to make sure that whatever that letter that you send to that patient, that's maintained in the patient chart or elsewhere. Hospitals, despite all of this, remember your EMTALA obligations, right? If you're a hospital covered by EMTALA, or if you're a physician providing on-call services or other services at the hospital through the emergency services, make sure that you comply with your on-call obligations. Here's a sample letter to a patient that you might consider using, something along these lines. This letter is a draft that I came up with a while ago. It's, it may not fit for every circumstance, but it gives you kind of the general gist of what you might want to say. Dear patient, due to recent events, I will no longer be able to continue providing your medical care. Accordingly, it will be necessary for you to transfer your care to another healthcare provider. Now, a lot of people will say, including your malpractice payer may say, don't tell the patient why you're terminating the relationship. I actually disagree with that. I think that it's better to tell the patient why you're doing what you're doing for a couple of reasons. One is patients get frustrated if they just get this letter out of the blue and they don't have any understanding, right? And frustration, that's what results in complaints and malpractice lawsuits and things like that. On the other hand, if you explain to them that, because you missed your appointments or because you have acted in a disruptive manner, it adversely affects our ability to provide care not only to you, but to other patients. And under these circumstances, we're unfortunately not able to continue to provide care to you. If you give them that kind of explanation, the patient may not like it, but at least they can understand it. The second reason is if this ever does go to court and you need to explain your actions, then a jury is going to be more understanding if you can show that, yeah, we set it out, rather than just sending this letter out of the blue without any kind of advance notice. So going back to that letter, I will continue to provide you with any necessary care until, and then give them the date certain, right? What is the date? That's 30 days from the date of this letter, or until April 24th, or whatever the date might be. make sure that you've got a date there so that it's clear when your treatment obligations end. That should give you time to transfer your appropriate care. However, after that date, you will need to obtain medical care elsewhere. Advise the person that they may need to get a necessary care. And if there's specific things that they need to get, you may want to be very specific in that in the letter. But generally, you might say something like, your condition requires continued care. I strongly encourage you to immediately take action to transfer your care to an appropriate healthcare provider. If you need assistance, then give them a referral source. Alternatively, your insurance program, local hospitals, or acquaintances may be able to refer you to an appropriate provider. We will make your medical records available to your new physician upon his or her request. Please have your physician contact our office to make arrangements to transfer the records. Again, this is just a sample letter, sample language you might use. It should be tweaked to fit your circumstances, but it gives you an idea of the types of things you want to address. Now, there may be situations, despite everything I just said, right? There may be situations that justify immediate termination without the advance notice. If you get a call from, or if I got a call from a patient or a healthcare provider says, hey, we just had a patient who just called in and threatened to come down with his AK-47 and take out our staff. What do we do? Well, in that situation, I'm not going to tell them, okay, send them a letter and give them 30 days to come down, right? In those situations, it may be necessary to do what you need to do to keep your staff and other patients safe. That's your first and foremost priority. But those should be rare cases. Ultimately, you're going to want to look at what a jury would think. Was your action justified under those particular circumstances? Not only what a jury would think, but also what the local licensing board might think. So be careful before terminating without that prior notice, the type of notice that you would give in advance to avoid patient abandonment. Make sure that you carefully consider the patient care needs, the availability of alternative sources of treatment. Are they going to be able to get their care elsewhere so that they don't suffer damage? What statutory obligations you have, including if you're covered by EMTALA, you don't have the luxury of refusing to provide care. What are the contractual obligations that you might have? Ultimately, what would a jury think? Now, once you have sent that letter, once you've abandoned that relationship or terminated that relationship, you have not abandoned the patient. Make sure once you've terminated that relationship, make sure you do not unwittingly resume that relationship by taking the patient back on. So during that 30-day period where you're going to provide care in the meantime, make sure that it's clear that the patient understands that, look, we're still going to terminate your relationship at the end. We're just providing you care, necessary care in the meantime. If they come in to see you after that relationship is terminated, make sure that you notify them that, no, we've terminated that relationship. We're not going to go ahead and see you. To that end, make sure that you notify staff so that they don't reschedule the patient and suddenly you're back in the soup again and they now created a new patient relationship. If something happens and they are improperly scheduled, then make sure that you terminate that. Or if you do end up seeing them, that you notify them that, no, this was an error. We're not going to continue to provide care to you, and you may need to consider whether you need to go through the proper steps to terminate that relationship appropriately in the future. All right, that is a summary of creating and managing and ending patient relationships. Again, as with all of our webinars, make sure that you are familiar with your own particular state laws or any particular laws or regulations that apply to your facility or provider type, because the general rules we've talked about today may vary depending upon your particular circumstances. If you need additional resources, we've published information on this topic as well as other topics, and those are all available at our website for free. Just a reminder of our upcoming programs that we've got. We've got a couple left in our compliance webinar series. If you'd like to participate in those and you haven't got those emails concerning those webinars, just let us know and we'll make sure that we add you to the list. If you have questions, feel free to shoot those to me either using the chat feature or send me an email and I'll be happy to address those offline. Otherwise, thank you very much for your participation and I hope that you have a good week and weekend.